Here we have Gönenç from Turkey, who is not at the Turkish Competition Board, but probably knows it better than it knows itself. So I think we cannot get better specialists here.
Thank you. I have strategically positioned Turkey between France and Germany. I'm in this panel, so the Turkish accession to EU is going well as far as this morning is concerned. I'm a private practitioner. I've been practicing competition law for the last 25 years, since there has been a competition authority active in Turkey. And I have seen a particular uptick in the merger control work that the Turkish Competition Authority is getting over the years. It's not comparable to what the Bundeskartellamt is doing with 1,000 files per year, and that seems to be a drop, actually. Our numbers are around 300, 320 merger control filings per year, and that is the last 2 years average. Before that, it was around 260 to 280, basically, filings happening. This doesn't mean that this is not a jurisdiction that's not active in merger control. To the contrary, I think when you look at the size of the economy and when you look at the prominence of the local companies, it's quite a high number, and a vast majority of these filings are foreign to foreign transactions with an impact on Turkish soil. The authority does a thorough job of reviewing in the sense that they are not very hesitant to throw something into a phase 2 if need be, but this is not one of the jurisdictions where you would see a phase 2 just for the heck of it. There are some jurisdictions you might know where there would be a phase 2 almost automatically, and then you would have to work your way through it. Turkey is not like that. In 2021, out of the 309 notifications, 2 were cleared in a phase 2. So a phase 2 is not a sure enough ticket that you're going to get into trouble either. Sometimes the board inoculates itself against future legal challenge by way of throwing something into a phase 2 and doing a more thorough job and then giving an approval decision. Then you get the hint of that from the case handlers as well. So the typical way to discuss that with the case handlers becomes, is this one of those instances where we will together do more homework, or is this that we're on a road to perdition and we need to do something about the transaction? And they would actually share that information with you. It doesn't mean that it binds the board, but it means that, you know, if the client should not panic and should not suddenly jump onto altering the transaction, that's, you know, there's room for that kind of further ammunition gathering. Because the courts are applying a very high degree of scrutiny over the competition authority, which is welcomed. It's a very litigious jurisdiction in all senses. So unlike the French take on things that companies don't like to see it through or take it to the court, Turks love a good controversy. So you get almost 95% of decisions that are changing the legal status in a litigation circumstance, which means if there is a complainant in a file, the board may tend toward a phase 2 if there is enough momentum or dynamic that warrants a phase 2 anyway, just because they anticipate that there might be a litigation. And in that case, generally, the administrative courts are more tending toward showing deference to the authority if they have launched a phase 2. If they haven't, it kind of feels like they haven't done their homework entirely. In 2002, in the first 6 months of it, we had 152 filings in Turkey, and there were 2 conditional approvals. I will just give you one very significant change in the Turkish system without getting too much into the substance, because we will have a second round on that. But I would like all of you to know that just in May of this year, we have changed the approach to thresholds in Turkey, which is quite significant and important, I think. So the Turkish thresholds were very, very low because they're defined in Turkish lira, and Turkish lira is weakening against euro and dollar and even pound. And so we're now seeing as this is not okay coming from a Turkish person. The Turkish lira is in a terrible, terrible situation at the moment. But the way it goes down, you're left with a very, very low threshold. Huh? And that has meant that a lot of transactions that really didn't have much of an impact on Turkey had to be filed. Together with it comes our tendency to have joint ventures filed in Turkey if the joint venture partners are meeting the thresholds in Turkey. So you don't have to have the joint venture active in Turkey. The structural link itself is reportable in Turkey if the parties are operational in Turkey, and then you get a lot of filings. So the push was that we're going to escalate the thresholds, which we did, but there was an exception defined for certain sectors. If the target is active in these sectors, and if the acquirer has more than 23 million euros worth of global turnover, which is basically anything worth talking about, then you file. And these sectors are digital platforms, so the target is active there, you file. Software, gaming software, financial technologies, biotechnology, pharmacology, agricultural chemicals, and health technologies. Thank you very much. Now, if you put these together in the life of a law firm, it's almost half of the filings you do in a given year anyway. And so what this has led to at the moment is that the board is using an accelerated procedure, but they really want to know about these. And this has been and this is my last sentence, I don't want to take too much of your time. This has been a result of a disparity between how cutting edge they feel their work is at the enforcement side versus their work at the merger control side is. In the sense that I, for example, have defended Google in 5 different investigations of the Turkish Competition Authority so far. So they feel the authority is very active in the digital sphere in terms of enforcement. But when it comes to Facebook Giphies or Facebook WhatsApps, whatnots of the world, the authority felt these are never getting notified to us because the target is absent in its monetization from our jurisdiction, and we're never taking a look at it. And when they had to investigate Google Android as well, they took this position for digital platforms. Then, as it so frequently happens in the bureaucratic corridors of any entity, once you define an exception to something, other chambers started throwing in, hey, mine is important too. And we ended up with this whole list, which then makes a lot of things notifiable in Turkey. I'm highlighting this because it's a bit counterintuitive. And when one is coordinating a global merger grid or an international transactions notifiability analysis, it may not occur that, Thales, for example, doing basically railroad work suddenly has to do a notification in Turkey because they have a signalization product on the side that they're commercializing, and that is actually software. So it's an issue at the moment. I wanted to highlight that for everyone. So I had reserved these few notes for you, thinking I was going to have a second round as well. One note I wanted to share with you is that in phase 2 situations in Turkey, you would want to note that the case handlers are quite active in engaging in commitment negotiations, but in phase 1, it's a closed box basically in Turkey. This is a cultural and bureaucratic cultural thing. So the case handlers don't know if the board members are going to agree with them that this is a problematic case and that this is going to be a candidate for phase 2. So in phase 1, if you wanted to come up with commitments, they would feature it, but they wouldn't negotiate with you because the board members may say, I hadn't told you that there's a problem yet. On what authority did you negotiate all this? But if it falls into a phase 2, then it's clear that the board is at the same page with the case handlers, and then starts the discussions. So phase one remedification is a bit of a one-way street. And one last sentence I wanted to share with you is that conglomerate effects and range effects are featured more prominently, more and more, in the Turkish theory of harm scene. And sometimes you even see that the Turkish authority goes beyond what the Commission in the EU has requested in the same matter. And we're not talking about them requesting a repeat of the same remedification in their own file, but we're talking about them saying, for example, ELIG is here. She's the head of competition department at Essilor Luxottica in a 2018 case when Essilor was taking over Luxottica. The Turkish competition authority said, I understand this complex set of commitments given in Europe, but our market for sunglasses and optical frames works in a different way, so we need more. It's not very frequent, but these things may happen, and it doesn't always happen to the more aggressive side. It may happen, as again with Essilor Luxottica, actually, it has happened in 2021. It may happen that the Turkish competition authority may make do with something less. So exact repetitions of remedies aren't as effective anymore. Thank you.